Good morning, good afternoon, and good evening. This is Doug Brunke from the headquarters of Global Chamber. We have a distinguished, talented, and experienced group of people who know immigration law today, and they're going to be taking different cuts of it. So if you have issues around immigration, you're looking to bring immigrants into your business, or you've got them now and want to keep them, stay tuned because we've got information for you. Our first speaker is James Hollis. He's a business immigration attorney at Siskin Susser in Nashville, Tennessee. He's going to kick us off with a conversation around immigration topics to watch. It's a hot topic, James, and so kick us off and kind of give us a sense of, what's happening and how do we keep score?
Sure thing, sure thing. Well, you mentioned that this is going to be for folks who want to bring immigrants into their businesses, and I have to start out the panel in a very similar way to what we've been seeing in the news, which is fear and difficulty. So what I'm basically going to do with my brief remarks is to give you some trends to look for in immigration law in 2019 as a way to better understand sort of what you're hearing from your attorney, and perhaps also, when you look at the news and you hear something, maybe something will ping and you'll say, oh, hey, that's this trend. That's what they're talking about here. As you no doubt know, the past 2 years have been an interesting time in immigration law. I don't think most of the immigration attorneys became immigration attorneys in order to be famous or to be in the news. However, as Doug said, since the start of the Trump administration, the changes that have made immigration law a very popular subject in the news. But as I said earlier, we're not really here to talk about popularity. We're here to talk about difficulty. And if you're anything like any of my clients, you understand that immigration in general and employment immigration in particular has become more difficult in the past couple of years. So, with deference to everybody else that's going to go after me, as quickly as I can, I'm going to talk about 5 trends in immigration law that will hopefully help you understand what's going on a little bit more. The first trend that I'm going to discuss is greater scrutiny across case types. Without new legislation, the Trump administration has done a great deal to increase scrutiny on cases of all types. Many of these changes are the result of changing regulatory interpretations via USCIS policy memos, which, if you're in business, you're probably never going to interact with because they're sort of dull and dusty. But from an immigration lawyer's perspective, when these changes are made, it's basically an alarm system goes off. Oh my gosh, something changed. And I know that there have been all sorts of changes across the past 2 years, and I would struggle to even list off all of them in 6 minutes, let alone go into any of them in detail. I think probably the most important one with regard to the new scheme that we're dealing with is the rescission of most of what are the so-called deference memos. And this rescission essentially means that USCIS is going to adjudicate almost all, there are some exceptions, cases, as if they're new, even if they've been approved many times before. So basically, if you've got a person who's been here on an H-1B for years and has an approved I-140 for a green card and is waiting for their visa backlog to go through before they can get it, and they're re-upping their H-1B each year, it basically brings that H-1B visa into contest each time, even though it's been approved 10 times before. The ultimate result of this is more uncertainty on the part of the employer and the attorney, frankly, and then stress on the side of the workers, as many of them understand that their time in the U.S. could be either shortened or they could have to go abroad while you have to go get a new petition approved. The second trend that I'm going to talk about is the Buy American, Hire American executive order, which was passed by the president in April 2017. Immigration lawyers will typically refer to this as BAHA because it's easier than saying the executive order's name. On its face, the executive order appeared to be quite innocuous. I remember when I read it, I was like, wait, what was that? Is that it? It contains a small provision at the end that discusses the proper functioning of the H-1B visa program to help ensure that H-1B visas are awarded to the most skilled or highest paid petition beneficiaries. Basically, it's very vague, but in its vagueness, it's also been incredibly far-reaching. Among other things, it's made it significantly more difficult to get cases through the annual H-1B cap without significant scrutiny. And it's also spawned a number of new requirements at consulates abroad, such as L1 and E2 visa applicants being asked whether U.S. Workers could better do their jobs, which is interesting. Ultimately, the effect is that it's more difficult to obtain standard employment-based visas like the H-1B, the L1, and the E2. This won't be a shock to anybody who's been watching the news, but the third trend is longer wait times. And this is for both adjudications and for immigration benefits in general. And by immigration benefits, I mean green cards and visas and employment authorization documents for workers and things like that. The most likely place you would have heard this is probably the H-1B visa category. This is because twice since the turning of the administration, premium processing or 15 calendar day processing has been suspended. USCIS, which is the organization that issues, basically approves petitions, indicates that this allows them to catch up on backlog cases, which is true. But practically speaking, the lack of premium processing chills the ability of numerous workers to transfer jobs because they're concerned that they'll basically get a denial and then either be knocked out of status or have to go resume their employment with their previous employer, which is, if you know anything about jobs, then that's relatively unlikely. The second premium processing suspension is still in effect. As of yesterday, USCIS opened up premium processing to the H-1B cap cases from fiscal year 2019. So basically the cases that were filed in April of last year. It's unclear whether they're going to open up premium processing to the H-1B transfers. I've heard people talk about end of February, and I'm hopeful, and I know my clients are hopeful of that, but it still continues. And then longer wait times is also a trend that you'll experience in employment-based green card cases as well, and also, frankly, as a result of that, family-based green card cases. And this is largely due to a change in October 2017, which created in-person adjustment of status interviews for all employment-based green card cases. Essentially, this increased the caseload of all USCIS officers in the local offices by about 30% without an increase in staffing. The result has been, obviously a longer period of time in the employment-based green card cases, but also naturalization case times have increased dramatically, as have family-based cases and removal of conditions on marriage-based cases. Trend number 4 is the one that, you're probably waiting for from the very beginning, which is increased immigration enforcement. And when I say immigration enforcement, most people think of an ICE raid into a factory, which those have certainly increased. However, it's just part of the story. In addition to the ICE enforcement actions, there have also been an increase in site visits to L1 and H-1B employers. And regardless of whether it's an ICE raid or whether it's a visit from USCIS's Fraud Detection and National Security Division, it's important for employers to make sure that I-9 records and any other regulatory requirements like H-1B public access files are properly maintained and have been reviewed recently to make sure that everything is in order. The final trend, and I think I'm about at the edge of my time here, and this is sort of one that I hope will continue, and that's lawsuits. And the reason for it is, like many immigration practitioners, I don't have a problem if USCIS, the Department of State, appropriately applies the law to the facts and denies my case. There are cases that are close, and I understand that sometimes I do have to lose, though I don't really like it. The problem arises when, cases that have been approved numerous times before are being denied and are being denied for reasons that aren't in line with the law and the facts and the evidence that's been presented. And the challenge for employers a lot of times is to try to get one of those cases turned around. The mechanisms that are available, or the regulatory mechanisms that are available, are very limited and they're relatively ineffective. So if you take a case that's been denied and you appeal it through the USCIS system to the AAO, even if you were successful, it can take 2 years of high risk waiting for your employee to get the case turned around, and the likelihood of success there is minuscule. I believe the amount of cases that are overturned are less than 5%. So what a lot of employers have begun doing is simply bypassing that regulatory mechanism and suing the government in federal court, suing USCIS in federal court, and having the federal court determine whether or not the law and the facts were applied correctly. What employers are seeing is, quick, effective turnaround on these cases, and they get the case approved, and the worker is able to continue working, or in the case of a green card case, they're able to have that green card petition approved. That's all I've got for trends, and I'll turn things back over to Doug, and I think Christine is going to talk next about H-1B visas.
That's it, exactly. Thank you for giving us that the lowdown on those 5 items. Really good summary. Thank you. For those of you who are watching. You can see the note there at the bottom. If you have questions, go to the chat room and enter them there, and we'll have roughly about 30 minutes of information like we just had, and then 30 minutes of questions, and so please send those in there. The next speaker is Christine Swenson. She's a founder of Swenson Law Office, and Christine's calling in from the Denver, Colorado area. She'll be talking about the latest on H-1B visa, which we've heard a little bit about already. Thank you, Christine.
Good morning, everybody. So it's cold here in Denver, and in order to prevent my jaw from freezing shut, I prepped some slides for you so that you'll have some context for what I'm saying and something to refer back to. Please know that we've had a great overview already of some of the things that I was going to talk about, so that's great. But for those of you who don't know, an H-1B visa is an employment-based visa, where a company is a sponsor of a foreign national employee, and that employee is performing work in a professional capacity and maintains a specialty occupation. And with all things immigration related, everything has its own phrase and definition that goes with it. A specialty occupation is one where someone has spent their time studying in a field at a post-secondary level, and that the career they're applying for has that background and application of that body of knowledge that they've obtained. So some examples of that, we'll see typically engineers of different fields, whether they're software, mechanical, geophysical. We have physicians and surgeons, graphic designers, accountants, economists, teachers, and so forth. So we have an opportunity to have it be a very broad category, which is fantastic for employers across the world. However, there are some pros and cons that go with this. One of the things to keep in mind is that it is a dual intent visa, and this is another one of those special immigration terms that we get to deal with. And what that means is that we basically have two categories of visas in the United States. The first one is an immigrant visa, someone who wants to come to the United States and stay here permanently. And the other is a non-immigrant visa, which is pretty much everything else that's out there. And it's the vast majority of visas that exist in the United States where your purpose is to come into the United States for a short period of time, but then you're intending to leave. The beauty of a dual intent visa is that you can maintain both of those concepts at the same time, which means someone who's here for a job doesn't necessarily have to plan to turn around and leave in 3 or 6 years. So that's a fantastic option for employers, especially when you're investing in a future employee and that employee starts performing the way that you want them to. You want to be able to keep them on. You want to be able to petition them ultimately for an immigrant visa and then allow them that opportunity to get their green card. A couple of other things, it is renewable for a total of a 6-year period. So the first year is based under that lottery. And you'll see all of those kind of in the cons section of the slide, but you can renew it. The good part is that the renewal is outside of that lottery. So once you have an H-1B visa, your renewal goes a lot smoother. It is useful for those who have families because you can bring your kids and your spouse with you. The downside is they're generally not going to be able to work until they're significantly later in the process. You may have actually heard about this in the news where we have heard the president say that he's going to terminate work authorization for H-4 visa holders. Those are spouses of H-1B visas. And so the problem with that is that usually when we're dealing with someone who's in a specialty occupation who has as much education as they do, their spouses are generally highly educated as well and are great contributors to our economy. In the grand scheme of things, while this tends to get headlines, the downside with it is that it's generally less than 1% of the workforce in the United States. So there's a lot of political interaction there, and frankly making it more than it should be. Another positive thing about the H-1B visa is that if you have a master's degree or a PhD, you actually get 2 shots at the lottery. There is a cap on this. There are certain positions of employment that are outside of this cap. That's what was talked about earlier when we were talking about the concept of cap exempt and cap subject. So if you're cap subject, you're going to fall under that $66,000 per year. And if you're cap exempt, well, great, you don't fall under that cap. Also, keep in mind that requests for evidence are being issued far more frequently than they have been in the past. And those requests for evidence are doing a higher level of scrutiny due to, in my opinion, a lot of the unpopularity and misconceptions regarding this visa. So those are kind of some basics and some pros and cons for you. I think I have another 2 minutes left, so I'm going to keep on moving through. To give you a very simplified outline of what this process looks like, is it's a pretty simple 5-step process. You need to have a job description, and it needs to be incredibly detailed in what that description includes. You need to make sure that the foreign national that you're wanting to sponsor actually meets those minimum requirements. And then just to make sure that no one is playing games with the employment system here in the United States, you need to make sure as an employer you're willing to pay what's called the prevailing wage. More often than not, our clients tend to pay more than that prevailing wage because they're already in a position of needing people in that field, and there just aren't enough people to fill those positions. So while technically that's not an issue, it is something that needs to be looked at. Fourth, we need to get essentially blessing from the U.S. Department of Labor to make sure that what we present to them on your behalf indicates that you are in fact facing a shortage within that field for employers and employees. And then the last step, which is always the easiest part, prepare the forms and submit that application. We're going to include a wide variety of supporting documentations. I know in our firm, in an effort to head off those what we feel to be unnecessary requests for evidence, we're starting to include more and more documents up front to save our clients money so that we don't have to worry about seeing that on the back end if they're selected. There are a couple of other things to note. This is the last slide for us. But one of the things I wanted to mention about about this process is that you may have heard at the end of last year there was a significant proposed rule change. They were going to do a few things, and one of the things that I think actually makes a lot of sense is instead of preparing these tremendous applications and submitting them in with the pure hope that they're going to get selected, that they wanted to start an electronic registration process. And that process is likely not going to go into effect this year. In fact, we're in officially H-1B season as we all prepare everything and get everybody ready to make sure it's received by immigration on April 1st or within a couple of days after that. But it would be really nice to be able to prepare all those applications only if in fact they are selected. So that's one of the proposed rule changes that I think actually is a good thing and would help everybody involved. One of the downsides is that proposed rule change also impacts a lot of other processes in terms of those who are within the master's and PhD categories and how those people are selected. Those are clearly contrary to statute and won't survive any sort of litigation once somebody gets around to doing that. But we were on pins and needles towards the end of the year whether or not we were going to have that put into play this year. And then on top of that, whether it was even going to function in time. We do have a similar electronic registration process when it comes to the diversity visa, so I know we have that capability in the system, and I think it would be a good one for us to use. And then lastly, please keep in mind it's very, very important, especially for those employers who are hiring recent graduates who are on their science, technology, engineering, and mathematics, or their STEM, occupational practical training, or OPT, that you make sure that there aren't any gaps in unauthorized employment. If necessary, as we talked about earlier, you may have to have your employee go outside of the country and then come back in once their H-1B is approved. That's everything I've got, Doug.
Great information, Christine. Outstanding. Thank you very much. Our next speaker is Jessica Weiss. She's immigration attorney at Weiss and Moy. She's calling in from Southern California. She's a great example of who we look for as a member. Every member, all of our speakers here are remarkable. We found Jessica by asking another member, hey, we need some help with Canadian immigration. Who do you know? And they came back, well, Jessica is the best. And subsequently, we found out beyond just Canada, she does other countries, and she also specializes in high net worth individuals, including sports and athletes. So she does remarkable work based in South Florida. You're going to talk today, Jessica, about E2 and O1A for business developers. Thank you so much for sharing.
Thank you so much for having me. So I have the first screen. This is E2, E1, and O1A. These are all non-immigrant categories, so nothing to do with green cards. These are ways for workers to come here and on a temporary basis. So on the next screen on E2 visas, there's some basic requirements if you're not familiar with the E2 category, where we must have an e-treaty with the foreigner's country where they reside in. We also, the foreigner must invest a substantial amount of funds in a U.S. business. There is no set figure you'll find anywhere. It's just a substantial amount. Usually we say 100, 150, but there's so many variations in this. Over the years, I've been doing this 20 years, and I've heard people doing it for 10,000, 75,000. So you really just need a qualified immigration attorney to help you with this process and figure out what's the best amount based on the business you want to buy. So you're either going to buy, the next one, you must create jobs for 2 full-time workers. So there's variations on that too. So again, these are the basics, and then there's some variations. The U.S. company must show current or future economic benefit. So this is an interesting one because it used to be when you file your case, you really should have the doors open to the business and show there's going to be some profit. Now you can show that you're going to have a profit in the near future by producing a strong business plan, and your case could possibly get approved, which is great because a lot of these businesses are very young when they start, and the foreign investor wants to come here and work at the business. It takes time to build it, so they need to be here. So on the next slide, the challenges the E2 cases are facing is there's a lot of scrutiny going on with these cases. Depending on the consulate where you file, sometimes they scrutinize more than certain consulates scrutinize more than other consulates. I work with a lot of Canadians. It's still a very smooth process, but one thing that does get scrutinized a lot is the E2 contingency clause. So some of these agreements, like you can either buy a business, an existing one, or start a new one. If you buy an existing business, you can set it up where there's an E2 contingency in the contract of the business you're going to buy, where it says that you are not going to put all the funds into the business until the E2 visa is issued by the consulate abroad. So there's certain wording that goes in the contract, but now they want to see, I'm starting to see more and more consulates want to see the escrow agreement signed by all parties. That is the seller, the buyer, and the escrow agent. And before we didn't have to do that. So there's definitely more scrutiny going on with an E2 contingency type of agreement. They're also requesting more documents. It used to be we just show sometimes a net worth statement of the investor. Now they want to see where are these funds really coming from. I had one gentleman, they wanted to see, he said they all came from paychecks, bonuses that he got from his work. They want to see those paychecks. They want you to trace those funds from the very origin, where they came from to buy the business. Also the processes, depending on the consulate again. Some consulates run 2 to 3 weeks it takes to get these cases scheduled for interview. Sometimes it takes 2 to 3 months. So it just depends on how fast the consulates are moving on reviewing the files. And each consulate has their own system of how they want you to send the documentation into them, and then how you set up the interview, etc. Now I get a lot of people ask me E2. So how do we turn the E2 into a green card? Because E2, they say, oh, I heard it's a dead end, whatever. So E2 doesn't have to be a dead end. Sometimes the E2s will turn into EB5s, which is a green card category for a foreign investor to put in their $500,000, $1 million, create 10 full-time jobs. There's a whole bunch of exceptions to these requirements. But if they don't have that kind of money, which a lot of my E2s don't, then I talk to them about what's called EB3, which is another green card category where they need to invest, where they need to have 2 years of full-time work experience usually and have a U.S. employer. So they don't love this because E2s are entrepreneurs, but they will do it sometimes because they want they want to get out of E2. The E1, which is the screen you see in front of you, is a category that's not used as often, but it's out there, where again we have to have a treaty, an e-treaty with the foreigner's country where they reside, and what they have to show is that majority of their trade, their worldwide trade or services, is between the U.S. and their home country. There is no physical office needed. There's no foreign workers needed in the United States. There's no substantial investment. So an E1 is really a great way to come here, but they have to meet this requirement, 50% or more of trade or services between the U.S. and their home country. The challenges with the E1 is proving that, proving the trade or services on the next screen. How do you prove that? Well, you need to show usually gross profits. You need to show where are these profits coming from. So we'll trace it and we'll see. And if they're not strong enough yet, if there's not substantial gross profits, then we'll say, you know, wait a few months, get some more trade going on between the U.S. and your home country. So E1 is out there. It's not used as often, but it's out there. The other thing that's interesting to note on the next slide is that sometimes you'll have the investor will come in on E1 or E2, or if he doesn't want to come in, you can have qualified workers come in. So they can come in as essential skilled workers or someone that's an executive, supervisor, managerial role. The issue with this is they really have to meet the criteria. Essential skilled worker is someone who has specialized skills that are needed to help the U.S. company develop. A supervisor or manager typically is someone who's supervising other workers. So this is a nice way to bring in other workers if the foreign investor could still come in, but he could also bring in some workers from abroad. Another category, the O&A, extraordinary ability on the next screen, is one of my favorite categories, and I do a lot of work in this area where applicants have to have national or international recognition in their field of endeavor. It can be any field, so you can get very creative with these. And what I'm seeing now is there's a lot more of O&As going on because if they don't fit into certain categories, like an H-1B or an L-1A, then we say, look, what's your national, do you have any national recognition, anything? And some of the criteria I list, or the actually supporting documents I list for you on the screen, show reference letters from peers in your field, publications, if you've written something, your name's been in something, if you've received a high salary compared to others. This category really works. It's a wonderful category. The issue with this category, as you'll see on the next screen, is it's very subjective. So you'll have a U.S. immigration officer who will look at the file, and by the way, the cases that we're submitting are getting larger and larger. I've been submitting almost 1,000 pages sometimes with these cases, and they'll look at the whole thing and they'll give their decision. Either they think they're extraordinary or they're not, and that's it. It's based on the documentation and the officer's opinion when he's reviewing it. More applicants, though, once they go for the O&A, which is non-immigrant category, they often want to go to the green card. There's a category in the green card employment-based world, EB1, which is very similar criteria. Problem is right now there's a backlog. And since I've been doing this over 20 years, and now we're seeing a backlog of almost a year in this category. So you have these O&As who are all excited to be an O&A, but they want to move on, and they can't right now. There's a backlog to move on to finish their green card. As I said, the documentation is getting extensive. And I can tell you this, that there is a strong future for E's. E's are wonderful. They create jobs for Americans. They bring money to the United States. E's have a strong future, as well as the O's. The O's are bringing the brightest and the best to this country, which is the trend right now, what this government wants. So O's are going to continue. The reasons they get denied on the next screen are that documentation has to be strong. On the O's, you have to have tons of documentation to show they have national, international recognition. And on the E's, you have to prove that you've invested substantial money. If it's an E2, where the money comes from. If it's an E1, that there's been significant trade, over 50% worldwide trade. And then on the next screen, just to give you an idea, I have actually on my website at attorneyjessicaweiss.com, I have lots of little just like this, screens that show the process to go from an E2, this screen says, to a green card, all the different options. And sometimes it's really helpful to just look at these, the processes to see how someone might qualify and how they can turn into a green card. And that's it. So thank you so much.
Wow, extraordinary information. Very fascinating. Our next speaker is Dobrina Dobreva. I think of all of our members speaking today, she may be the longest involved with Global Chamber. So thank you, Dobrina, for your working together with us and your collaboration. You are the founder of Dobreva Law, based in Dallas. And so we're looking forward today to hear more about TN, L1A, and a little bit what we just heard on EB2. Thank you, Dobrina.
Yes, that is correct. Thank you. So I will start with a TN visa. That's a non-immigrant visa under the NAFTA agreement between U.S. and Mexico. And basically it allows citizens of Canada and Mexico to come and work in the United States in the prearranged business activities. Among the type of professionals, they're eligible to seek admissions as TN non-immigrants are accountant, engineers, lawyers, pharmacists, scientists, and actually the whole list is available on the CBP website. I think we have over 80 professions or somewhere around that number. Generally speaking, depending on your business and your company, if you're trying to hire people from Mexico or Canada, that's a good option. Assuming they qualify and they fit into the profession. There's no quota for TN. So that if you don't get your H-1B for your Canadian or Mexican employee, you can try the TN. You can file the petition or apply at the consulate throughout the year, so there's no cap, so to speak. Now, having said all these good things, of course, there's some challenges with the TN as well, like with everything else. So what happens if your employee doesn't necessarily fit in any of those professions? Well, they have this category profession called a management consultant. I call it like sort of like a catch-all. However, since it's a catch-all, everybody is trying, if you don't fit in anything else, everybody's trying to take advantage of that management consultant designation in order to bring their employees here. It's not impossible, you have to be really careful, how you draft that job description, and how the employee present their case either at the consulate or at the border when they get their visa to come into the United States. In terms of getting the visa, if you're a Canadian citizen, you get actually your TN at the border. You present your documentation at the border with the CBP officer, and hopefully, if you're lucky and if they're in a good mood, you get your visa stamp and you come into the United States. For Canadian citizens, it's usually for 3 years length, the TN. You can extend indefinitely, assuming you have the prearranged work opportunity in the United States. It's a non-immigrant visa, and basically doesn't necessarily lead to a green card in theory. Of course, there are other mechanisms you can use, which I'm not going to go into, but generally speaking, it's a non-immigrant visa. Now, if you're a Mexican citizen, you have to schedule an appointment with the U.S. consulate and go for your visa stamping interview in the U.S. consulate in Mexico. For Mexican citizens, the TN is given for 1 year, and then you can renew again indefinitely, assuming that you have that job opportunity still remaining in the United States. It's a good, as I said, it's a good alternative, assuming you qualify. For example, some of the examples that we just did one for a Canadian Salesforce architect. That he didn't really fit into any of the professions. He didn't have the degree required, but he had the experience, and he applied at the Canadian border in Toronto, Pearce Airport, and it was even though we requested only 6 months because that's how the project was assigned for. He got it for 3 years, so it was I guess lucky. I don't know, but as I said, it's a good alternative to H-1B, assuming you qualify, and I just have to keep in mind that obviously we have some challenges with the TNs as well. Moving on to the L1A, shifting gears. L1A is called L1A Intercompany Transferee Executive and Managers. So L1A, it's a dual intent, meaning that you can remain on your L1A visa, or you can apply, once you're here on L1A, you can file for your permanent residency. It enables your employer to transfer an executive or a manager from one of its foreign affiliates to an office in the United States. Also enables a foreign company which does not have an office in the United States to send an executive or manager to for the purpose of establishing an office here, or the so-called L1A new office. This is a little bit similar to the E2. Of course, it has different requirements, but some people see it as a startup visa or investor visa. It's sort of none of that. It's kind of in between. But it's a good way if you have a company in the, outside the United States and you want to have presence here, you can open up a new office and get your L1A initially for 1 year, and then you file an extension. Qualifications, how do you qualify? Have to have a qualifying relationship with a foreign company, either parent, a branch, subsidiary, or affiliate. Currently be or will be an employer in the United States. Have been working for the foreign company for at least 1 year in the preceding 3 years before you get transferred to the United States. And be seeking to enter the U.S. To provide services in an executive or managerial capacity. Again, there's the current trend. Actually, I mean, it's we have a lot of challenges right now. I'm, being totally honest, especially with the, with the L1A new offices. It's something that, at least I haven't seen in the past. That you submit as much as evidence possible, and then you still get your request for evidence, and the government is, it's not happy, or all sorts of mechanisms that basically it takes longer to get the approval. Obviously, if you're a larger company and you transfer your executive or manager from your foreign office abroad to the U.S. office, it might be slightly easier, but they're not exempt from the scrutiny, the current scrutiny on this type of visa. If it's for new office, it's given for 1 year, and then you can do multiple extensions up to 7 years. And if it's a regular L1A, you get 3 years, initial 3 years, and then you can extend up to 7 years. And then the last one, I think I still have 1 minute maybe. The last one, actually, I'm shifting gears, and actually I'm going to talk about a little bit about the permanent residence or green card under the EB2 national interest waiver category. So this is actually one of my favorite categories, and case types that I work on. So generally speaking, a foreign national needs to have a employer willing and able to sponsor, and a job description. A job offer in order to file for permanent residency. However, if the employee can show that his or her expertise and skills are of national interest, they don't need an employer, and they can self-sponsor themselves. The process works really well for PhD candidates, postdocs who have exceptional abilities, and or you can show that their skills will be in the national interest of the United States and would greatly benefit the nation. However, if you don't have a PhD, you can still qualify. The requirement is you have to have a master's degree or higher. If you have PhD, USCIS, obviously wants to see publications, citations, conferences, impact in the industry. So what happens if you don't have PhD? What happens if you just have master's degree? It can still work. It's just that for that particular petition, we would focus on the beneficiaries' work and how that work impacts the national interest. For example, we had a software engineer only with master's degree, didn't have citations or publications, but because his work was in healthcare, in the healthcare industry, where he was developing certain 3D ceilings and floors and walls that they were installing in hospitals for kids with cancer, sick with cancer, and that was, around the United States. So that was, basically that was the national interest. So even though he didn't have PhD, no citations, no publication, because the work was in national interest, he was able to go through that process and self-sponsor himself for permanent residency. And I think that's all what I have.
And that's a lot, and that's a lot of really good information. Thank you very much. Our last speaker before we get to the Q&A section is Elizabeth Kambari. She's the Vice President of Professional Exchange Programs with Cultural Vista. She's also legal counsel there. So Elizabeth, thank you for today talking about the J1 visa intern and trainee exchanges, another type of visa. Thank you.
Absolutely. Hi, everyone. Good morning, good afternoon, and I'm excited to talk to you about specifically J visas. You know, I should start out by saying J visas are actually very different than the other visa types we spoke about because they're actually housed or part of Department of State. And so Department of State, this is a cultural exchange visa type, and within that there are 300,000 different J visas issued a year, so it's quite large. There's 14 categories in there, and so there's things like exchange students. Your physicians are often coming on J1 visas from other countries, researcher categories. And the ones I'm going to talk about specifically are intern and trainees only. What I should also say is that intern and trainee visas are not pathways to permanent residencies. These are not for long-term hireability options. What they are opportunities to expand your workforce, to internationalize your workforce, and to bring a different dimension to your workforce. So often when I talk to companies and they say, how would I utilize a J1 visa? So imagine this. Imagine you're at a conference and you're in Germany and you're meeting a wonderful individual who you want to open up your new EU office. And in order to get them started, you want to bring them to the United States to understand how your company can work, to understand the culture of your company, to understand the ins and the outs of different types of work that you're doing. And then this individual is going to go back to their home country or to another country and open up your other branch. That's a perfect example of a trainee visa. So this individual could come to the United States, learn your company culture, learn the skills for up to 18 months. So it's quite an extended period of time. It could be as short as 3 weeks. Another option would be to bring somebody over as an intern. So why would that be of interest? Or I often hear, why would I open that up internationally? Well, there's, obviously international components and the cultural components, but why would you limit your company's intern program only to Americans? Perhaps you want to have the intercultural experience within the internship program. So again, the trainee program is for any individual from 3 weeks to 18 months. These are individuals who could be at any level in their career. It really is important that they're going to have a learning objective. So they actually will have a training plan that says in the first 3 weeks they will learn this, next 6 weeks they'll learn this, at 9 weeks they'll be learning this type of opportunity. They can go to many different sites. So you may be a company that has 5 different offices that specialize in different things, and that would be wonderful for the trainee visa. An intern visa would be an individual who's currently enrolled in a post-secondary education program that needs to be recognized by their government. They can come for 3 weeks to 12 months. We see individuals who come over the summer break. Those may come for multiple times over summer breaks, for 1 year and then perhaps the second time. As long as it stays within that 12-month limitation, they could do that. And this is, we see this work with companies anywhere from small fashion design organizations to many of our clients are Fortune 500 companies. What is very different about the J visa is that it's not through the Department of Labor, as I said, it's through the Department of State. And so what is very specific about that is that you must actually work with a J sponsor, and that's what Cultural Vistas is. And so what does a J sponsor do? So our role in this is we actually review the training plan and the educational requirements that you as a company would be looking to provide to an intern or a trainee. And then we also check the background of the intern or trainee and make sure that they're qualified, make sure they have proper English ability, make sure that they have no limitations on visa restrictions. As a J1 visa sponsor, what we would then do is we would issue the documentation that would be required for the visa application. So in this case, it's called a DS 2019 and DS 7002. So those are the documentations. This process is very fast. So once we have the documents from both sides, it could take us 5 days to issue these the documents to go to the visa application or the visa interview. So 5 days, generally it's 20 if they're not paying for expedite turnaround, but you could actually meet somebody at a conference, go back to the United States, and within the month you could have this international trainee on site learning about your organization. So it's very fast moving. Other differentiators are that the participant, the intern or the trainee, could actually pay the administrative fees, which range from $775 to maybe up to $2,000 depending on duration. So it's substantially less expensive than some of the other options, although it is a shorter period of time. All of these require cultural experiences. So we require host companies, so the company that would be sponsoring the J applicant or the J participant, to actually have some cultural activities that they could participate in. And those could be things like potlucks or attending a baseball game. So that does need to be a component of what they would be doing. Overall, again, 300,000 J visas a year. Companies, large J sponsors, we currently work with 1,000 different host companies a year. We're 4,700 different visas every single year. And so there's a large opportunity for companies, both big and small. Small, we require, 5 employees at your site, but big and small, to host an intern or a trainee for anywhere from 3 weeks to 18 months. And while there are some restrictions and we're seeing some of the impacts of the Buy American, Hire American Act, it is still a relatively straightforward, smooth process, fairly predictable, again, running out of Department of State as an educational opportunity for intern or trainees.
Thank you very much, Elizabeth. Great information. And so now we're going to shift over to the Q&A, and we do have several questions. The first question kind of relates maybe on a macro level. The number of international students in the United States has decreased the last 2 years, which I think is maybe never happened before, but certainly it seems to be unusual in the last 20 years. What visa is that, and what are you seeing on the magnitude of impact of some of the changes that you've all talked about? Are we seeing decreases in other areas as well? And
I'll jump into this. That's the student visa is the F1 visa for undergraduate, graduate, PhD programs. And an option with that is your optional practical training or your curricular practical training, which is on-the-job training after graduation. The latest IE and Open Doors reports actually show that current international students are at a rise, but that has to do with the longevity of optional practical training extension. So now that individuals can stay in the country longer. From a J1 perspective, we are actually seeing individuals come more often on internships if they actually want an on-the-job training. Perhaps they wouldn't complete a full degree program in the United States. So we see somebody come specifically for 6 months of on-the-job training through an internship versus completing an F1 master's degree and then deciding to go and do an optional practical training option. And we are hearing increased scrutiny of optional practical training opportunities, whether or not it's related to the degree program or it's the correct company for them to be completing that.
Okay, great information. What are we seeing with some of the other visas?
At least in the last 2 years since we've been under this administration, there's actually been a brief decline or a short amount of decline in the number of H-1B applications that have been submitted. I think that's the first time, and colleagues please chime in if I'm off, but I believe that's the first time in a decade that we've seen the number of applications for this type of visa actually decline.
Gotcha. Okay. Are there any areas where there are increases happening?
I could share with you.
Sure.
So I've had students approach me and say, what am I supposed to do? Where am I supposed to go? I may not be able to get an H-1B. And I say, what about an E-2? If you can be gifted money and you can get an E-2, you can start your own business. It doesn't matter what age you are, as long as the money comes from a legal source. I am seeing, foreigners invest money. It may be a small business, but I'm seeing that as one option. Not the E1 and, they need more years of experience usually, but the E2 might be an angle for some of these students.
Okay. And that goes to the creativity that all of you sometimes need to use, right? In terms of figuring out how to get someone in. Great. And so for all of our speakers today, if we don't get to you on a particular question, feel free to either answer later when you're talking, or we'll have a blog post and fill that in. Another question, and I'll just read it pretty much directly because it took me a couple minutes to, this is from Gabriela Castro. Here's a case. An American company hires the services of a person who works for a Mexican company, but the American company then pays the salary to the engineering of the Mexican company. So they don't really pay the person directly. Does the engineering technical person need a visa if he or she is not paid directly in the United States? Anybody know the answer to that one?
Who handled our L's?
Oh, I'm sorry. Go ahead, Christine.
I was going to say, who was the one who presented on L's for a minute? I think you'd probably be the best one to answer that.
Is the individual in the United States?
The person's working in the U.S., but they're being paid by the Mexican company, by an American company. So the American company pays the Mexican company. The person's in the U.S. being paid presumably in pesos.
I don't think. I mean, if it's a new office that they have they've opened, I think that is allowed in the first year. But I don't think they can continually do that. I mean, they have to have some sort of a payroll in the United States, and that also raises the question as to how much are they paying them? Because for L1A, it is true that we don't have a prevailing wage, or the company, the employer is not required to pay a certain wage. But if you're hiring a manager or an executive that it's going to work for you in the United States, the salary has to be reasonable. And if they're paying them in pesos and it's $25,000, and that's a manager who is managing a company, clearly that's not reasonable. And when the time of extension comes, they will have issues with with that salary and the manner of basically how they pay that employee in the United States.
Doug, can I add something to that?
Please do.
Yeah, so I've worked with companies, and sometimes they're very large companies, and sometimes the workers in the United States are paid by the foreign entity abroad. It's all commingled together. When it's a very large company, sometimes the funds do come from outside the U.S., but you have to show that you can pay that person's salary. So even if it's a foreign entity paying the salary, I have seen that. But what Dobrina's saying about it has to be a reasonable salary, has to make sense for that kind of position in the company. Those are all important factors too. But I have seen it done where it's paid by the foreign entity.
Okay. Oh, that sounds good.
Well, and I might add something as well, because I may have read something slightly or heard something slightly different in the story there. I mean, it sounds sort of like the person's trying to determine what the scope of the activities that are allowed in the U.S. are for somebody that doesn't have a specific work visa and is being paid through a foreign entity. And I mean, I've seen that quite a bit. There are basically the rules surrounding that are laid out in the essentially what's allowed in the B visa regs, and also in the Foreign Affairs Manual when it's discussing work that's available on a B visa. Typically speaking, the rule is that you can't come and do work that a U.S. worker would otherwise accomplish, but that's not exactly a helpful thing. So I mean, typically speaking, if it's you're training someone, or if there's a specific contract that the person's on, then you might look at the B visa, but otherwise you're really going to need to figure out whether you're probably going to need a TN or an L1 visa. So the activities are very constrained that you can actually accomplish on a B visa without work authorization.
Gotcha. Several of you, when you're talking about the people that are coming in, have used the word he. And so the question is regarding the gender balance of people, particularly maybe like starting with the E1, E2. Are you seeing more opportunities for women coming from other countries? How does that pan out? Are there trends?
It's equal. I mean, it's really based on, sometimes you'll have the spouse, the male spouse, who says, I want the opportunity to work anywhere. So they want that work permit. So it's a decision between the couple who qualifies really for the E2. We like to see something in their background that's some kind of skills that they're going to use to develop their E2 business. But we also look to see who needs that opportunity for the work permit to work anywhere, that they don't want to just be tied down to that E2 company. So we're seeing more of that. It's not necessarily always the male spouse that's taking the E2, being the E2 investor. I am seeing more of that. I feel it's getting more even.
Yeah, in terms of the other visas, I mean, most of my clients are in tech, so I think I have higher number of male clients. So I guess it's just depending on the field.
Okay. Does the government look at men, women differently based on what you've seen? And another question related to that is, are there certain styles that you do working with the government to have more success? I presume being rude doesn't work, right? But so how do you deal with the kind of responses that you would typically get there? And do they have biases that you sometimes have to work around?
I think there are biases, and I think part of it is a large part of our job is education. There are a lot of officers who are thrown into a significant and substantial caseload without significant training. And so a large part of what we do is we will go out of our way to educate the officer who's reading it. I've gone so far as to color code documents with what things meet which criteria so that they can find them more easily and lead them almost literally to giving us and I think at times, we have our own individual state listservs. I think we vent a lot there to get through some of the snarkiness we get in response from some of these requests for evidence. And then we have to go through a lot of our own self-care too.
Gotcha. I think back to Jessica's 1,000-page report, to justify, it's mind-boggling. Gabriella, actually, the one who asked the previous question, is now on the line. Gabriella, did you want to add something?
Yes. Thank you very much, and thank you for all of you to provide all this good information for companies in the U.S. My question is about, I asked the question about an American company paying a Mexican company, and the Mexican company paying an engineering that is working in the U.S. So I understand that there are constraints, but I've seen, and sometimes I talk to people at the airports that are coming to the U.S. to work like engineers or technical services, and they are paid by the Mexican company, but they come and work in the U.S. And I would like to know what's the best way to do it.
Well, I guess the question is, how do they come? Do they get a work visa, or as James was alluding, do they come on a visit?
That's what I want to know, if they need a work visa or not, because they are not paid in the U.S. They are paid in Mexico. And they are paid a good salary, but they are paid in Mexico by the Mexican company hired by the American company. So I want to know exactly if it's possible, how can we do the best way, and if they need a visa.
Well,
because they are not paying here.
How often are they coming in? And how long do they stay when they come in?
It could be 6 months or more, at least 6
months. Why are they not going for a TN? Sounds like they need to move towards a TN as an engineer.
Okay,
So I think Gabriella?
Yeah.
So we're just about at the end of the time. So here's what I suggest for you and anybody else that's listening. The purpose of going through this today was to identify remarkable people who are doing some spectacular work for companies and individuals. And so for you and for anyone watching, I would suggest connecting up with any of these 5 people. If you have trouble through the directory to find them, let us know. Send an email to info@globalchamber.org and have that conversation. So feel free, Gabriella, to touch back to any of the folks that have spoken today And I want to thank all of you for speaking. We're come to the end of our hour. There are actually quite a number more of questions that we're not going to get to, but what we'll do is if any of you are watching and have some additional questions, we'll pull that together with other questions that have already been asked, and we'll ask the participants today and get some additional responses, and then typically we'll post this on a blog in about 7 to 10 days out. So thank you all for speaking today. We're right at the time right now. Our next event is 1 week from today, where we're going to be talking about project management, global project management and cross-border project management. It sounds like maybe we better talk about visa management along with that as well. Thank you, everybody. Stay warm. Have a great day.